Slip and fall injuries, time limitations. In Indiana, the statute of limitations for a slip and fall injury is 2 years. This means a claim must be filed within 2 years of the date of the injury. This 2-year period starts ticking the moment a person is injured in a slip and fall. Failure to make a claim within this time period results in a person forever being barred from filing a claim. There are exceptions, of course, particularly for minors. If a person is under the age of 18 when they're injured in a slip and fall, they have 2 years from their 18th birthday to file a claim. So if an injury occurs at age 16, well, that person has until age 20 to file a claim. These rules generally apply to private entities. Different rules apply if the government is involved. For example, if a person slips and falls at a publicly funded hospital or police station, well, that person must serve what's called a tort claim notice on the government agencies involved. While there are some different time limitations for different types of government agencies, it's the best practice to serve the tort claim notice within 180 days of the slip and fall. Failure to file a tort claim notice will result in not being able to recover for the slip and fall injury. Of course, there's different rules for minors. So a person generally has 2 years to make a claim. I can't stress this next part enough. Please do not wait until the last minute to start a claim. Slip and fall injuries are unique as they do not typically leave behind objective physical evidence like a car crash would, such as a damaged vehicle. The evidence in a slip and fall case primarily comes from medical records, witness statements, photos, and videos of the scene. It is crucial to act quickly before this evidence becomes unavailable. Over time, witnesses change phone numbers, and videos and photos are often become lost by the business. And here's the hard truth. Slip and fall cases are hard, and they don't become easier with less evidence. Slip and fall cases depend heavily on the evidence closest in time to the injury. If one waits, crucial evidence is likely going to be lost. My law firm has had numerous people wait months or even a year to call us, and by the time they did call us, witnesses had changed phone numbers, stores lost video, and landowners had changed or even gone out of business. All of these things significantly weaken an otherwise strong slip and fall injury case. It is so very important for an injured person to contact a slip and fall attorney as soon as possible. Most injury attorneys don't charge upfront fees. Their compensation comes from the money they earn for their clients. So it makes no sense not to get a slip and fall attorney involved as soon as possible. On a side note, here at the Marc Lopez Law Firm, we receive calls every week from people who are close to the 2-year statute limitations because they thought they could handle it themselves. But then they realize it's almost impossible for the average person to navigate insurance law, lien law, and the law of premises liability. And oftentimes we have to tell these people that we can't help them. It's because each case we take requires significant time and resources. And when people call late like that, we can't justify putting our time and money into a case where evidence has likely been lost. Don't wait to get an attorney involved. Many who have suffered slip and fall injuries experience frustration. Allow the Marc Lopez Law Firm to turn this frustration into compensation. Give us a call, 317-632-3642. And don't forget to like this video and subscribe to the channel if you found this information helpful. Thank you for watching.